A summary of everything that is stated in this video may be found on the CoinMarketCap website. Additionally, I would ask that you support my channel by liking it and subscribing to it so that you can stay up to date on future XRP news, as well as other cryptocurrency news in general. Take a look at this now, shall we? The legal dispute between Ripple and SAC has escalated, with SAC launching a fresh appeal and XRP lawsuit. On the other hand, before we go any further, there is a brand new cryptocurrency airdrop that is currently taking place on Telegram and is set to start at any moment. I would ask that you make sure that you take part in this airdrop. Within the video's description is where you will find the link. Make sure you don't miss out on this opportunity. In the meantime, let's proceed with our video. Ripple is going to respond to the SEC by submitting its Form C civil appeal for review, which is scheduled to take place today. The blockchain-based digital payment network will particularly appeal the prior finding that the court issued on its XRP institutional sales. This decision was made in relation to the network's XRP sales. In order to better understand the classification of the token, the network is looking for clarity. The leadership of Ripple is of the impression that the ruling handed down by the Second Circuit would result in beneficial outcomes. There was no violation of federal securities laws committed by Ripple when it made programmatic sales of XRP to retail consumers. This ruling led to the finding that XRP does not fall within the category of securities, as stated by a decision that was handed out by District Judge Annalisa Torres on August 7th. In light of the fact that the Securities and Exchanges Commission was dissatisfied with the ruling that was handed down by the court, they filed an appeal in order to have XRP consider itself to be a security even further. It is anticipated that Ripple will submit its appeal in the form of a Form C to the United States Court of Appeals for the Second Circuit early today. The ruling that the district court ruled down on its institutional sales, which were considered to be unregistered securities transactions, will be the principal topic of the appeal that will be filed. On the other hand, officials from Ripple, including Brad Garlinghouse and Stuart Alderode, are feeling optimistic and looking forward to a triumph over the United States Commission as a result of the filing of Form C. What follows is a conversation that took place between Eleanor Tourette and Brad Garlinghouse. I am absolutely certain that we will prevail in the appeal that we have filed, and that would prove to be a fatal blow to Gary Gensler's entire plan on the regulation of cryptocurrencies. Ellie, if I'm being completely honest with you, I don't have any second thoughts about it at all, since I am of the opinion that we are on the right side of the law. To say that I am confident about this matter would be an understatement. With regard to the course of history, I believe that we are currently on the right side. I am Brad Garlinghouse, if you will. In addition, Stuart Alderode shared the same beliefs as Garlinghouse, and he was of the opinion that collaborating with Garlinghouse would lead to yet another win over the regulating agency. The argument that Alderode made was that the Second Circuit has a history of being critical of regulators and regulatory overreach, which increases the likelihood that they will triumph in this case. Ripple Labs is of the opinion that negotiations with U.S. regulators need to have taken place within a far earlier time period. Brad Garlinghouse, the chief executive officer of Ripple, gave an interview to Nia Mitchell of CNBC during the DC FinTech Week conference. In the interview, he shared his perspective that he believes his network should have contacted authorities sooner. It is only now that his network is attempting to recover from the financial losses it has incurred and the legal challenges it has encountered. According to him, his network made a mistake when it delayed negotiations with the United States Commission. Garlinghouse, on the other hand, did point the finger at Gary Gensler, who works as the chair of the Securities and Exchange Commission in the United States. According to his argument, Gensler was the one who was responsible for putting up barriers for digital assets. He went so far as to attack Senator Elizabeth Warren for her erroneous portrayal of the facts of cryptocurrencies. He claimed that she had misrepresented the facts, and in one of his pieces he voiced his endorsement of John Denton, the Republican candidate for president who is currently vying for office. Earlier this week, on Thursday, the United States Securities and Exchange Commission (SEC) submitted a petition to the United States Court of Appeals for the Second Circuit, seeking that the deadline for the filing of its major brief be extended until January 15, 2025. James K. Phelan, a former federal prosecutor and defense attorney, disclosed the document that had been submitted through a post that he made on his website. Additionally, within the same time frame, Ripple Labs submitted their pre-argument statement to the same court using Form C. This statement provided an overview of the concerns that the corporation intends to appeal to the Second Circuit Court of Appeals. It has been argued by the United States Securities and Exchange Commission, SEC, which is chaired by Gary Gensler, that the ruling made by Judge Annalisa Torres, which states that sales to XRP through cryptocurrency exchanges do not represent investment contracts, but rather sales to institutional investors, has been contested. Ripple, on the other side, has filed an appeal in which they are asking more interpretation of the Howey test which pertains to digital assets, more especially the XRP. In the United States of America, the presidential and congressional elections are scheduled to take place in 2024. There are fewer than 2 weeks left until the elections, and Ripple and the entire cryptocurrency world are counting on the probability that Donald Trump will win. Particularly noteworthy is the fact that the Republican candidate for president has made a commitment to advance the cryptocurrency business in the United States. To this end, he has committed to remove Gary Gensler from his post as chair of the Securities and Exchange Commission on the very first day of his presidency. If the incoming administration makes the decision to dismiss all outstanding charges and crypto persecutions, then the Securities and Exchange Commission (SEC) will be collecting significant losses by January 15th, according to Jeremy Hogan, a well-known attorney who is involved with the cryptocurrency industry. Some analysts have predicted that the Ripple VVs will bring in a significant amount of money. In the year 2026, the lawsuit brought by the SEC will be concluded. Concern has been voiced by members of the XRP community on the prospect of lost chances during the alt season, which is anticipated to take place over the course of the following several months. In addition, during the bull run that took place in the year 2021, Ripple and the Securities and Exchange Commission (SEC) filed a complaint, which had a substantial effect on the cryptocurrency market. The trial attorney Fred Rispoli, on the other hand, is of the opinion that the world central bank's WCCC influence over XRP has drastically decreased over the course of the recent past. In the continuing dispute against the United States Securities and Exchange Commission (SEC) concerns XRP, the blockchain firm Ripple has submitted Form C for their cross-appeal. This pertains to the proceeding that is now underway. Only a few minutes before the deadline, this contribution was provided, expressing his unhappiness with the steps taken by the Securities and Exchange Commission. Second, hinting that the SEC's appeal may be more about delaying the process than it is about having confidence in their case. According to the recent ruling that Judge Torres issued has been highly accepted, which raises questions about the reason why the Securities and Exchange Commission is not acting more quickly to overturn it. This is because the verdict has been well received. On August 7th, following the final verdict handed down by Judge Torres, the Securities and Exchange Commission (SEC) filed its notice of appeal, which was submitted just before the deadline of 60 days. As an additional point of interest, they were tardy in submitting their Form C, which led to arguments on whether or not it was a day late. Currently, the Securities and Exchange Commission is demanding that it be granted the entire 3 months to file its brief, which would be equivalent to 5 months after the final verdict has been issued. Does the SEC simply not have faith in the reasons that they have supplied, or is the delay a purposeful consequence of the situation? On the other hand, Mark Fagel, a former attorney for the Securities and Exchange Commission, suggested that the agency might be taking as much time as possible. This is something that is typical for litigators, especially in the realm of the government system, where there are multiple layers of review for papers. In response, a user mentioned that this might be the reason why the Securities and Exchange Commission, def 14.7 days to file Form C, contended that the delays appeared to be intentional to generate confusion and doubt in the market, which may potentially prevent individuals from investing in cryptocurrency. Despite the fact that Fagel has claimed that he is not aware of the precise reasons behind the steps taken by the Securities and Exchange Commission, he has stated that the agency is acting in accordance with the law. In addition, he stated that in order for Congress to demonstrate that they are serious about making the process of Bitcoin more transparent, they must move the process along as quickly as they possibly can. It should be noted that the material that has been supplied is not intended to serve as business advice. In the event that any investments are made on the basis of the information that is provided on this page, there is no responsibility for those investments. Prior to making any choice on investments, we strongly recommend performing independent research and talking with a professional who is educated in the field.